submission to make. On 29th, your lordship had made an order saying the board shall conduct final. Just kindly see the 29th January order. The controversy was they had advertised about 11,000 posts. 9,000 and odd people were the selected people. We were the ones who were saying that we are about 2,000. We were the ones who are saying that we, though qualified in 2022 December, we should also be appointed. It transpired in the hearing before the other court that there were 11,000 vacancies, everybody could be accommodated. So the court made this order on 22nd January saying, those 9,000, may I read para 2? As per the said affidavit, 11,758 posts in different subjects in various categories were advertised for the post of assistant teacher for primary classes. After furnishing the detail of the number of candidates who applied in response to the advertisement, it has been averred that as per the draft list prepared by the respondent, 9,533 candidates qualify, which includes an additional panel of 5% in accordance with the rules. It is stated that a total of 2108 DL candidates have been found to be not qualified amongst the pre-2020 batch. That's not us. It is further stated that d.el.ed candidates from 20 to 22 course have not been considered in the draft list due to issue pending in the present matters. That is us. This is us. Having regard to the fact that as against 11,758 posts in different subjects in various categories, respondents have found only 9,533 eligible candidates, including the additional panel of 5%, it is deemed appropriate to permit the respondents to declare the merit list with a rider that it should be stated in clear terms appointment shall be subject to the outcome of the petition. Letter of appointment issued to the candidates shall also state that their appointments will be subject to outcome of the petitions. This was a consent order actually. We also agreed, even though we had got the stay earlier. The board shall conduct final interviews and aptitude test for the candidates from 20 to 22 batch, that is us, and submit a report within 6 weeks from today with copies furnished to the other side. Now, my lord, they have filed some affidavit where we have been interviewed, but no final list has been displayed. If they tell your lordships how many have qualified, then the whole litigation will finish.
The number is
No, lordship, the issue of qualification will only come once this issue is
the rest of 2513
which is there at page 5 of the impugned order on interpretation of rule 6.
Pursuant to this order, anything, whatever is.
Yes, it is filed. It is filed only because once the issue is decided, then we'll come out with the list who are
what they have
clearing and who are not passing the exam.
What they have said is
Probably what they are trying to
That will complicate the situation.
If they are accommodated, then they have.
yes,
They may not
end
be
of the
eligible.
story.
The issue of qualification remains, my lord.
Yes.
in fact,
Take
my lord,
your
they
instruction next
in
week
fact, my
we'll
lord, they
have-
say so in the
When will
affidavit.
They say out of the 2572 candidates,
come in July. Then
All
by
right.
then whatever
Yes,
instructions
no,
they have.
The issue of qualification remains, my lord.
Issue of qualification will remain because the moment we disclose this list, these people
well,
will
the
start
board which
advocating.
is making the most noise supported us in the High Court. They filed their
That's
affidavit.
under terrorism.
High Court allowed it on their stand. And now he's making the most noise standing here because we were fair on the last date. We said appoint 9,000. Now they have got their bit and now they have decided to turn adverse to us.
We are not
Before,
not to decide
when
the
there
issue
was a stay,
so that whoever comes
When-
whoever goes out.
all right, when there was a stay, they were very much with us.
They need clarification.
We were never
Para
with
E, my lord. If your lordship sees this affidavit,
List.
para E, if it is clarified, my lord, by the board, everything will not fall
No,
in place.
that's-
Of the affidavit 29,
Otherwise it has to be heard of.
Yes.
it is there, my lord. 29th of,
The
Lordship,
date of the affidavit
I'll
is
just-
20th March.
Yes, Lord. 20th March, Lordship, I have affirmed on 20th March. I have filed immediately thereafter. Lordship can have my compliance affidavit.
Para E, it's a thick volume because they had the whole.
I have filed because that time that circular was not there that we have to give the date of filing.
I have a thin file, my lord.
It's a separate paper.
Page 11 of
The relevant page I have.
It's some 500, almost 500 pages affidavit.
But your lordship sees only one page, my lord. I have this one page.
It's must be some little substantial.
This only one page, my lord, if your lordship sees.
It is not there on the board, my lord. It is-
Lordship may, I don't know what
Page
is
to be
been
seen.
handed
That
over.
is, para E needs clarification, my lord.
Lordship, I don't know what is been handed over.
Para E of your affidavit.
I don't know what is
Out,
handed
out
over.
of, if you read page 11, you will know. Unless you read it, you will not know. Out of 2572 candidates, board has conducted verification of documents before conducting interview and aptitude test and found 59 candidates having problem with their documents and have rejected them. For the rest of 2513 candidates, marks have been retained by the board. Now, I don't know what this means, which means that they have some kind of a list. If they can give the list of 9,000 with this affidavit, they can also give our list.
Yes, correct.
They are not being very fair, because we were fair and we said, all right, you can appoint 9,000. Now they have had their way. Now they have decided to contest us. It's not very fair, my lord.
We were contesting from day one. We filed vacating application and everything because our impression was created at the date of getting the interim order, something different from what is actually in place.
Let me see the impugned order for a minute. That issue needs to be
What should be
decided
fair?
first.
Yes, my lord. Issue
We've
of the
been also
qualification
waiting,
has to
Lord,
be.
we have
Lordship, issue of the qualification goes to the root of the matter.
Kindly have the impugned order for a minute.
Let them give the list.
Page 5, impugned order, if Lordship sees, interpretation of Rule 6.
Page 4, in fact, 4 and 5.
That has been supported by the board. I don't know.
That till
why
that
they
time that
continue
issue is not
this
decided.
here.
This
Yes.
relaxation was given by whom?
But
There
the
was no
board,
relaxation.
the board,
Yes,
the
Lordship,
board,
there
the-
was no relaxation.
please see the advertisement. Just kindly see.
That's what
page.
Honorable Division Bench
My lord,
said.
we can't. Two people can't argue. Please see page 219. Please see page 219. The advertisement issued by the Board of Primary Education. We were qualified as per that advertisement, and now he is making the most noise standing here. Please see page 219.
That is what
The board-
bench has quashed, my lord.
Yes, but then the board should not oppose it. Please see page 219, my lord.
We are not.
This is the
supposing- we are
notification.
only saying let the issue be decided so that the complication
This
doesn't
is-
happen.
This is the notification.
You created this mess.
Correct.
I bow down, Lordship.
Correct.
It's a question of you having second thoughts.
It's
Correct.
You laid the foundation.
I
for
bow
their
down,
entry.
Lordship. It should not have been done.
You cannot oppose them,
can
is
you-
what we are saying. You
Correct.
created this
Correct.
litigation.
Absolutely.
When the order was
Absolutely.
vacated,
Under what circumstances?
Thoughts now.
Lordship, under what circumstances?
That makes your bona fides highly suspect.
yes, and
Lordship,
even
it's
when I'm
something
repeatedly
maybe
saying,
different.
when the order was vacated, he was one with us.
Impugned
I'm repeatedly saying it, my lord. When the order was vacated, he was one with us, and we said, all right, there are 11,000
If
posts.
Lordship
Everybody
wants,
will be.
we can give their results in a sealed cover to your Lordship.
And kindly have the clause 3B, the second clause, the TET qualification.
What we'll do is it on 16th, keep that list ready,
16th of July.
16th of.
Lordship, 16 may not keep because that SSC matter is before.
All right, let it be next week, not
23rd.
23rd.
On that day, keep that list.
We'll give the list to your Lordship in a sealed cover.
When it is being heard.
Yes, Lordship.
That bench will receive it in sealed cover or ask you to open and give it. That
I'll leave it to you.
Give us, my lord, we'll verify.
Lordship may pass that
We'll
order.
cover business, my lord. We don't know, we can verify it at least.
The results cannot be given like this.
Why not? Where's the mark?
9,000 results he has put with his affidavit. Rest of the results can't be
An
given.
order
There was no
notice.
dispute about their eligibility.
List on 23, 7, 2024. On the said date. In addition to the affidavit has already been filed by the respondent board,
Yes.
the list of results getting the marks obtained by the
Two five, the number may be given, my lord.
shall also be kept ready.
Lordship may say d.el.ed 2020-22 batches
That will
because
be-
petitioners are a small number out of that 2020. We are taking everybody.
The rank list of selections during 2020.
Those who got qualified for d.el.ed in
Your
the batch
Lordship
of
may just say-
2020-22.
No, your lordship may just say list of persons mentioned in para E of the affidavit dated so and so.
Persons mentioned in para E of.
Affidavit
affidavit
dated
be kept-
20th March.
Be
20
kept ready.
Correct. That's all.
Para 13, Lordship, not para E.
Para E.
Five, para E. Para E.
Page?
Page 11, my lord, it's page 11.
E. That is para 14.
That's okay.
is it?
That's okay. Read
14E.
paragraph 13 at page 10.
14E.
14E, my lord.
14E.
Oh, yeah.
Para 13 actually gives the table.
Para 14E.
14E. Grateful.
It is to be kept ready. Yes. 23rd.
Great,
Great.
grateful minutes.